Hi everybody. Let us see the rights of an unpaid seller today. So I am Dr. M. Vijay Kumar, Professor and Head, Department of Management Studies, K.S.Rangasamy College of Technology. So before getting into the subject, let us see what is who is called as unpaid seller. In the contract of sale, the buyer and seller are involving. The buyer and the seller is offering something, offering a good to a buyer, and the buyer is accepting, and he has to pay for that. If a buyer is not paying the due money to the seller, then the seller is called as an unpaid seller. Let us see the rights of an unpaid seller. The seller of a goods is deemed to be an unpaid seller when the whole of the price has not been paid or tendered, or where a bill of exchange or other negotiable instrument has been received as conditional payment subject to the realization thereof, and the same has been dishonored. Then the seller is considered as an unpaid seller. Let us also see the characteristics of an unpaid seller. He must sell the goods on cash terms and not on credit, and must be paid. He must be unpaid either wholly or partly. Either whole amount is not paid to him. Even if a part amount is not paid to him, then also the seller is called as unpaid seller. He must not refuse to accept payment when tendered. If the buyer is giving payment, the seller should accept that. If he should not refuse to accept it. So what are the rights of an unpaid seller? An unpaid seller has twofold rights. They are rights of the goods, right of the unpaid seller against the goods, and right of the unpaid seller against the buyer. Let us see the goods first. Rights of an unpaid seller against the goods. An unpaid seller has the following rights against the goods, notwithstanding the fact that the property in the goods has passed to the buyer. The goods is passing to the buyer, but he is not paying for it to the seller. In that case, the seller has the following rights. They are right on lien, right of stoppage of goods in transit, right of resale. Let us see the rights one by one. What is the rights of lien for a seller? The term lien means the right to retain the possession of the goods and refuse to deliver them to the buyer until the price due in respect of them is paid or tendered. So here the seller can retain the possession of the goods and he is not passing the title of the goods to the buyer until he pay the money. That is right on lien. Then right of stoppage of goods in transit. The right of stoppage in transit means the right of stopping the goods while they are in the transport or transit to regain the possession and to retain them till the full price is paid. For example, the seller is delivering the good to his vehicle, but the agreement is when the goods are started from the seller, the buyer has to pay the seller, but the amount is not being transferred. So in the transit, the seller may have a right to stop the goods. That is a right of stoppage of goods in transit. Another right of a seller, if the buyer is not paying the due money to the seller, that is a right of resale. It is very valuable right to be given to the unpaid seller in the following cases where the goods are of perishable nature. That means it will not last longer. In that situation, the seller can have to sell it or else it will be wasted. Another case where this right is being given to the seller is where such a right is expressly reserved in the contract in case a buyer should make a default. If it is expressly reserved in the contract and if the buyer is making a default, then the seller can resell the goods. Another case is where the seller has given a notice to the buyer of his intention to resell and the buyer does not pay or tender the price within the reasonable time. If a buyer is not paying the seller due money, then the seller has to send a notification that if you are not paying this money in a due date, I will make a sale, resale. So even after that, if he is not responding, then you can sell it, resell it. The next right is right of unpaid seller against the buyer. That is, in this situation, the seller can suit the price, suit the damages, suit the interest, repudiation of the contract before the due date. Let us see all these things one by one. Suit for the price. That means when the goods are passed on to the buyer and the buyer has wrongfully neglected or refused to pay as per the terms and condition of the contract, the seller may sue him as per the section 55 subsection 1, because once the property has been passed, the buyer is bound to pay the price. So the goods are passing to the buyer, but buyer wrongfully or refusing to pay the price for it. So in that case, he can suit for the price of the contract. And the seller can even go for suit for the damages. That means if there is a wrongful refusal by the buyer's part for acceptance of the goods and payment for money, the seller can sue him for damages of the non-acceptance as per the section 56. For calculating the quantum of damages, section 73 and 74 of the Indian Contract Act applies. Here the buyer is refusing to pay the money even after accepting the goods. So in that case, the seller can go for damages of non-acceptance as per the section of the 56. And another case for the seller to sue against the buyer is suit for interest, as stated in the section 61, where there is a specific agreement between buyer and seller with regard to the interest on the price of the goods from the date on which payment becomes due. The seller may recover interest from the buyer. But if there were no such agreement, the seller may charge interest from the day he notifies the buyer. It should be mentioned in the contract. If it is mentioned that from the due date, if you are not making payment, then the seller is entitled to receive the interest money. If it is not mentioned in the contract, then the seller is notifies anything through a letter. From that date, the seller is entitled to get the interest rate from the buyer if the buyer is not making even after the due date. Then the fourth case in which the seller has a right against the buyer is repudiation of the contract before the due date. According to the section 60, the rule of anticipatory breach contract applies, wherein if a buyer repudiates the contract before the date of the delivery, the seller can consider the contract as rescinded, can sue for damages of the breach. Here the buyer is repudiates, that means cancel the contracts before the date of delivery. But they have agreed, they have entered the contract, but he cancelled before that. So in that case, the seller can sue for the damages of the breach, because he have agreed, he have made the goods ready to send it to the transit. So everything is going to be waste. So to cover that, he can go for damages. So that's it about the rights of an unpaid seller. So thanks for watching. Keep learning and growing.